big Second Amendment decision, we're dealing with some very big issues within it that definitely applies to other states. This particular issue is coming out of the Federal Circuit Court of Appeals in the Second Circuit. We're talking about Antoniuk versus Hochul. We're talking about New York State. We're talking about laws that could easily migrate to every single place. Guys, let's get into it. Okay, so right up front, this is a 261-page decision. I am not going to be able to cover everything. However, I think that we're going to be able to faithfully capture the gist as to what's going on, and we're going to deep dive into a couple issues so that you can see how these sorts of clashes and ideas play out if you actually do want to go ahead and read them. Now, importantly, we're talking about this in the context of what's called a preliminary injunction. A preliminary injunction is where we're talking about enjoining and stopping a law from going into effect. Why do we talk about this? Because there's always someone in the comments section that says, don't do a video until the case is over, because generally speaking, these cases are won or lost on the injunctions. Not because the injunctions themselves are determinative, but because the issues that feed into whether or not an injunction is granted or not will predict the outcome of the case. That's the reason why we covered these. So really quick up front, I think you can divide these issues into two different sides of the coin. We're going to be talking about licensing issues as well as location-based issues. I'm going to start with the wins and then go through the losses, because this is going to be a very divided opinion where the plaintiffs in the Second Amendment wind up winning on some issues while losing on others. The licensing issues are going to be dealing with whether or not folks have to turn over their social media accounts, not the names and passwords, but simply identify which ones they recently use, whether folks, when they apply for a license in New York State, have to turn over the names and identifying criteria of folks that they cohabitate with. So think friends, family members, spouses, long-term partners, girlfriends, boyfriends, that kind of stuff. And then kind of a nebulous catch-all provision, which basically keeps the door open for licensing agents to come back and ask for additional information. On the sensitive locations and the locations front, we're dealing with where the government can restrict and ban firearms. We're talking about treatment centers, so alcohol, behavioral health treatment centers, that kind of stuff. We're talking about places of worship, parks, zoos, locations that are licensed for alcohol consumption, as well as First Amendment gatherings. And then here's a big one that I've been railing on for quite some time, what I like to call the private property inversion. This is going to be huge, and we're going to get to it, so be sure to stick around, because it deals with where the government presumptively makes it illegal for you to carry a firearm when you're out and about in private property. So you're going to the store, you're going to the mall, you're going to all those sorts of places. And they make it a crime for you to carry a firearm unless they post a firearm saying that it's legal for you to carry there. As opposed to virtually every state where it makes it legal to carry in one of those places unless the private property owner restricts it with signage. Here, New York State inverts that. They flip it. So we're going to power through this quickly. So first, the social media issue. This one winds up going down as a win, and the Second Circuit Court of Appeals actually upholds what the trial court, that's the district court when we're talking about federal courts, how they also enjoin this. Specifically, the circuit court ruled that disclosing one's social media accounts, including ones that are maintained anonymously, forfeits anonymity in that realm, and basically conditioning a right which concealed carrying and carrying a firearm in public is a right now. This is indisputable. If it was before, it is no longer disputable, thanks to the Bruen decision and the Heller decisions. And that you cannot condition one right, the ability to carry a firearm in public, on forfeiture of another right, the ability to maintain anonymous speech. So basically, cutting through a lot of stuff, that's the gist to it. The court ruled that neither the founders nor successive generations required forfeiture of a speaker's anonymity in order to facilitate an inquiry into character or dangerousness when it comes to licensing issues. For places of worship, super quickly, the ban is unconstitutional, but the injunction against it only applies to the specific plaintiffs here. The plaintiffs here, we're talking about Pastor Spencer at the Tabernacle Family Church, its members, their agents, and licensees. Here's where we get to an issue I'm going to do a little bit of a deeper dive on, which is the private property carry ban as being mostly unconstitutional. Mostly. And I already covered what this is. That's where the government can basically set all private property as being illegal unless someone posts it. Now, keep in mind that approximately 91% of New York State is private property held, meaning that this portion of the law, if it stands, reflexively makes 91% of New York State immediately restricted locations where it is illegal to carry a firearm. Now, we need to distinguish something between private property that is held open to the public versus closed to the public. Your house probably is closed to the public. That's a perfect example of something that is closed to the public and is private property. Something that is open to the public but is private property. Think about most retail establishments, restaurants, shopping, things like that. It's open to the public, but it remains private property. The court's going to be dividing between these two. Now, recall that thanks to the 2022 Bruen Court decision, for those of you in your lawnmowers, that's B-R-U-E-N, the 2022 Bruen Court decision, that the government bears the burden of proof to show that a law or regulation falls within the nation's historical tradition of regulating firearms. These laws cannot be mere historical outliers, and they must be representative of the nation's attitudes. Just because some township once did something somewhere at some time does not now mean that every place can now adopt that particular outlier as being representative of the nation's attitudes when it comes to the Second Amendment. If the government cannot establish that a current law or regulation, or one that's being challenged, falls within that nation's historical tradition, then it is going to be no good. Now, there's exceptions to everything, but that's the gist as to where this all fits. Finally, also recall that the Second Amendment has been concretely ruled to protect firearm rights disconnected from any militia service. More on that much later. So the government here trots out 8 laws from the 18th to 19th century that prohibits the carrying of firearms onto private property as basically their ace card to demonstrate that, yep, you cannot carry into a Walmart because of these laws. The problem is that 6 of those 8 laws were for the explicit purpose of prohibiting people from hunting. And in some of those laws, we're dealing with people who were already explicitly convicted criminals. Even the court won't go for anti-poaching laws as being somehow analogous, and closely analogous at that, to someone wanting to simply conceal carry at a Walmart or other private property that is held open to the public to protect themselves from criminals. These are 2 very different things, despite what the government's trying to argue here, and the court thankfully throws the flag on that. Now, the remaining 2 laws we have to deal with, one comes from 1771 New Jersey, the other one comes from 1865 Louisiana. They both prohibit carrying of firearms onto private property without the owner's consent. The district court, that's not the court that we are in right now, that's the court that this case came from originally, the trial court, held that these 2 laws from these 2 places were not representative of the nation's historical traditions, given that at the time that those were enacted, that they accounted for approximately combined 4.2% of the nation's population. 4.2%, not exactly representative. Bottom line, here's the outcome on this. The court in the end enjoins and stops the law from making all private property that is held out for public use from being illegal to start to carry unless it's posted. So in other words, that portion of the law that targets private property held out for public use, so think Walmarts, retail, things like that, that's now enjoined by the Second Circuit Court of Appeals. However, it has left in place the private property that is not held out for public use to remain to go into effect. So generally speaking, think about homes and maybe certain businesses that are not open to the public. So think about maybe an office environment or something like that where the public doesn't necessarily traffic. Now, to be clear, I'm not drawing that line there. We would really need to talk to a New York State attorney. If you're one of those people, or if you know one of those people who qualify to speak on this subject, have them reach out to me. You'll figure out a way how to do that. I'd be more than happy to follow up with them, perhaps bring them onto the show, get some more details for our friends in New York State. I heard there's 4 or 5 of you, at least, who are out there. So open question as to whether or not someone's office that has no strong public coming into it, like foot traffic and so forth, is going to be considered open to the public in New York State or not. Open question. So there you go. That's where that all winds up right now, as well as some questions. Now we're going to get to the L's. We're going to get to the losses. But before we do, guys, if you're enjoying this video, be sure to hit that like button. It tells both myself and Derek you want to see more content like this. It tells the algorithm that you support this kind of content. It'll show you more of it, both from this channel as well as others. And it's also a great way to take a moment and be free to support the Second Amendment. Here comes the losses. So we have the catch-all disclosure. The catch-all disclosure that I touched on before deals with the licensing process when you're applying for a license. And basically, it allows a licensing agent, that's the government, to ask the applicant to provide any follow-up information or forms required by the licensed applicant and to submit any and all other requested information required of the licensing officer that they believe to be reasonably necessary and related to the review of the licensing application. This is an outcome loss. Why? The court rules that basically this is not an issue protected by the Second Amendment, at least in the context of a facially unconstitutional challenge. I promise I'm not going to make this technical. There are different ways that you can challenge the constitutionality of a statute. Here, the plaintiffs, the people suing, chose for what's called a facially unconstitutional challenge. The gist to a facially unconstitutional challenge is that in order for the plaintiff to succeed, the plaintiff must show that basically in every single case, it must always be unconstitutional. So theoretically, if a court or the respondent, that's in this case the government being sued, can show that there are some cases, maybe perhaps many cases, where the application requests could be permissible, then okay, then it may not always be unconstitutional. So the law here can be summarized like this when we're talking about facially unconstitutional challenges. A facial challenge to a law is really just a claim that the law or policy at issue is unconstitutional in all of its applications. The court can imagine, however, as they rule here, that in some instances, it is not going to always be unconstitutional, and therefore the court basically says that the vehicle used to challenge this statute is incorrect in this instance. It is not facially unconstitutional, and basically they leave open a long line that you can read into saying, but it could be unconstitutional as applied, separate discussion. The court uses the example, what happens if licensing officers want to follow up with an applicant for some only very minor follow-up information from the applicant, such as maybe some missing identifying information. That's what the court says. Don't get angry at me. So that would seemingly draw on this particular statute's catch-all authority, and therefore, hey, this is now going to be failing on a facially unconstitutional challenge. And as a result, we're not going to enjoin it. That's basically what the court says. So that's a little bit of a dive on that. The cohabitant disclosures basically comes down to this. The court says that it's appropriate to look into someone's character for trustworthiness as well as for dangerousness. And if we're going to be doing that, and if we're going to be allowed to look into someone beyond the mere status of a criminal record, then it makes sense that we're allowed to reach out to people who maybe they live with, who they cohabitate with, who are family members. And if we can do that, then it makes sense that we can reach out to ask for the identifying information for those people so that a licensing officer can reach out to them. Again, I'm not endorsing this. I'm simply letting you know what the court reasoned here. Now let's turn away from some of the licensing issues and into some of the things that I think are a little bit, well, they're all important, but I think a little bit more of an interesting discussion. First, and if you've seen our other videos, you know that I oftentimes talk about the fact that, look, standing was an issue in this case, but I'm not covering it. I'm just going to talk a little bit here. So for those who kind of follow a lot of our videos, you'll hopefully get a little bit of a crash course on what standing is, because the plaintiffs, guys, they lose on standing on a lot of these issues, which results in a lot of these issues just getting dismissed. All right. So let's quickly cover what standing is. In order to sue someone, you need to have standing. So for instance, if I see a car hit a pedestrian who is legally crossing the road, and let's say the car is, for the sake of the argument, 100% at fault. And let's also say I have no relation to the person hit. I have no relation to any of the people involved in this. I am not allowed just to sue the negligent driver because, among other things, I lack standing. Standing goes to the premise that we have to have some gatekeeping in order to keep our justice system from getting just overwhelmed with an avalanche of crazy and potentially frivolous lawsuits. Now, in Second Amendment cases, standing is invariably always coming up when we're talking about someone who is civilly suing a new gun control law. I say civilly suing to contrast these cases, like here, where the plaintiffs are suing civilly, as compared to cases where someone has been arrested, charged, ticketed, their business has been shut down or something like that, because typically those kind of government actions is enough to give someone standing. Now, Civilly, you must show that you have standing to challenge the law. The gist of standing in a context like this, again, this is the low resolution version, is that courts are to consider whether the plaintiff's intended conduct is arguably prescribed or prohibited by the challenge statute, not whether the intended conduct is in fact prohibited. So as an example, if the plaintiff says, I intend to do X and I think that the law blocks X, that may be enough to establish standing. Emphasis on maybe. If the plaintiff's interpretation of the statute is reasonable enough, and under that reasonable enough interpretation, the statute does legitimately stop that and create the legitimate fear that they could face enforcement of the statute, then the plaintiff likely has standing to challenge the statute. So in order to make that determination, courts are generally not to defer to the government's interpretation of the statute or to its representations regarding whether or not they're going to be likely to target that particular plaintiff for prosecution. So the government can't just say, look, we could go after that person, but we don't intend to do it, and therefore they lack standing. That's not a justifiable defense in order to get a lawsuit dismissed. The bottom line takeaway is keep in mind, without standing, your lawsuit will be done. Standing's a huge deal, and it comes up, I kid you not, in virtually every single one of these Second Amendment civil cases. Even though you don't hear me or others talking about it, trust me, it's there. Okay, so with that discussion out of the way, let's whip through some more issues. Treatment centers. I'm going to do a deeper dive on this because if you can see what the court does on this, you can kind of extrapolate and see where they go elsewhere and everything else. So this is going to be my last deep dive. The New York law prohibits possession of a gun in any location providing health, behavioral health, or chemical dependence care or services. Now recall that there are many different plaintiffs that have all been lumped together in this lawsuit. The court dismisses all but one of their claims due to standing issues. So again, standing issues just winnowed the field here, and not only in this issue, but in other issues as well. The remaining one plaintiff who does have standing to challenge this, let's take a look at what the court did. The long short is that the court ruled that there were two 1837 militia laws from Massachusetts and Maine, as well as a third one from 1843 Rhode Island, that excluded people from militia service who had intellectual disabilities, mental illnesses, or alcohol addictions. And that was basically enough, according to the government and their filings, to form a national tradition sufficient to uphold this law. Obviously, there are at least three major problems here. One, the New York law now under review denies people who do not have any of those issues the right to carry to those treatment locations and within those treatment locations, whereas the militia laws only dealt with people who actually themselves had those conditions. That's a major distinguishing factor. Two, the militia laws dealt with people who were explicitly in service of the militia and had nothing to do with their ability to possess firearms outside or disconnected from militia service. Here, the court conflates government-compelled militia service with someone going into a treatment facility, whether they're the patient, an employee, or just a guest or visitor. Three, the existence of three militia laws across the entire arc of hundreds of years of history, stretching from perhaps the 1500s England to the early American Republic, in my view, is hardly representative of American and colonial tradition. What is more striking to me is the lack of any such historical analogs that prohibit people from carrying firearms into medical establishments back in that time frame, such as hospitals, doctor's offices, things called almshouses, and so forth. This could be the basis of a proper analogical review where we're taking A and comparing them to B. But here we are. Apparently, folks who were disqualified from militia service are on equal enough footing to somebody who just wants to visit or work at a treatment facility. And consequently, if you can see how not only the treatment issue was lost, but also taking this kind of reasoning, how all these other issues between the standing as well as court stretching things when it comes to the historical tradition analysis pervades the rest of the 261-page opinion when we start talking about parks, zoos, premises licensed for alcohol consumption, theaters, and as well as First Amendment gatherings. If you want to see a deep dive on any of those particular issues, post it up in the comments section. I'd be happy to do a follow-up video to look at that. But for right now, this video is dragging and I don't want to get too long on this. Let's close it out with our ever popular quote of the day. This one comes from Sun Tzu. Quote, "Respond intelligently, even to unintelligent treatment," end quote. Hope you enjoyed this video. I look forward to seeing and joining the discussion in the comment field below. Don't forget to hit the like button. And also, Gundy's voting are going on right now. You still have a week to vote for our channel. Breakout Content Creator of the Year, as well as Top Voices of 2A. I certainly don't expect to win anything. The field is packed. It's great just to be in there. I look forward to seeing you again in the comments section. We'll see you in the next video. Thanks. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.